EU Court rebukes Commission for limited transparency on COVID-19 vaccine deals. By Satori News. In a significant turn of events, the General Court of the European Union has admonished the European Commission for its opacity in the disclosure of COVID-19 vaccine procurement contracts. This rebuke comes in the backdrop of simmering discontent among members of the European Parliament regarding the handling of the procurement process, which involves some of the most pivotal vaccine suppliers, including AstraZeneca, Sanofi, GSK, Johnson & Johnson, BioNTech, Pfizer, and Moderna. With the EU under intense scrutiny during the pandemic's peak, the Commission's decision to maintain a veil over specifics of the deals has raised questions about the integrity of its operations and public accountability. At the core of the controversy are text messages exchanged between Ursula von der Leyen, President of the European Commission, and Pfizer CEO Albert Bourla, which have not been disclosed. The Commission has faced criticism, particularly for claiming that these text messages were not retained, fueling further suspicion and demands for transparency. Members of the European Parliament sought to inspect the documents to scrutinize the contract terms, but faced roadblocks in the form of redacted documents, with the Commission citing protection of commercial interests and its decision-making procedures. Unconvinced, some legislators have championed the pursuit of clarity, culminating in a challenge sustained by the court in Luxembourg, which underscored the insufficient access accorded to the vaccine purchase agreements and invalidated the Commission's defense of commercial privacy protection. The court's judgment directs the European Commission to reconsider its stance on document access, emphasizing that such transparency would not, contrary to its arguments, compromise commercial interests. This decision arrives at a critical juncture as a vote to determine von der Leyen's potential second term as Commission President looms on the horizon. Amidst these deliberations, the European Ombudsman identified instances of maladministration the previous year, lending credence to the standpoint that the Commission's withholding of the text message exchanges constituted a dereliction of administrative responsibility. Further fuel to the fire is added by the New York Times legal action seeking the release of the correspondences. Looking ahead, this ruling signals an imperative for the European Commission to adapt and align its document disclosure practices with the expectations set forth by the judiciary. With the specter of more joint procurements to address crises in public health and defense, Kim van Sparentak, one of the legislators who brought the complaint to the court, regards the ruling as precedent-setting. The Commission, tasked with the stewardship of myriad joint endeavors, now faces increased pressure to revamp its transparency policies, to forestall future legal interventions, and to restore faith in its governance mechanisms. The ruling serves as a pivot for ensuring that the Commission's conduct aligns with the values of good governance, and that similar opacity is not encountered in future collective procurement operations within the EU framework. Thank you for choosing Satori News.